SJC-13635, Commonwealth versus Manuel, Diaz.
Mr. Warren.
Good morning, and may it please the court, John Warren on behalf of Manuel Diaz. There was no valid reason for the stop of Mr. Diaz, only an invalid reason. He was stopped because of his race. Both of the constitutional violations in this case required suppression of the drugs. First, as for Article 14, attenuation factors 1 and 3 indisputably favored Mr. Diaz. And while there was an intervening event, Mr. Diaz's flight was directly...
You concede that the exceptions to exclusionary rule apply?
Could you say that again, Your Honor?
That the exceptions to the exclusionary rule apply in the equal protection?
Sure, Your Honor. My argument with respect to the equal protection is that attenuation is going to apply differently.
Right.
And would Your Honor...
When we go through the factors, right? Please.
Correct, Your Honor. And so turning to equal protection, I would suggest the case is even stronger, and that this is the case to put into action what Chief Justice Gant said concurring in Long, which is that the prohibition against racial profiling must be given teeth. So turning to Your Honor's point about how the case is going to look under equal protection, I think there's three things I'd like to highlight in this case about how the factors would apply differently. With respect to factor 3, not only is racial profiling incredibly flagrant, but I'd ask the court to look to the purposes of racial profiling, one of which is to do just this. It's to look for contraband based on improper stereotypes about the color of someone's skin.
Can I ask you on flagrancy, when we look at equal protection, because it differs, of course, from search and seizure law, as we've said in Dilworth, in other cases in Long, one way to violate equal protection is to run a license plate where the driver is completely unaware that that happened, right? That's a violation of equal protection.
Correct.
Could lead to, is that an example of where the flagrancy of unlawful conduct is less than that of a physical stop of a person?
Perhaps I would say, Your Honor, that
should we look at the
racially motivated police conduct, we're going to say
it's not right. I just wonder if it's a self-fulfilling prophecy if you say the third part of attenuation, because it's an equal protection violation, means it leads to exclusion. What I'm asking you about is if we break down the equal protection violations to stops and physical interactions with people versus running a license plate on the street corner, is that a way to judge flagrancy?
Sure, Your Honor. I think the fact that someone's physically being stopped, forced to, their privacy interests are being invaded, would make it more flagrant, as we have in this case. And so I would agree with Your Honor. Yes, you should look to that. And
it also has to do with the quantum of the police misconduct, in that if someone, right, that's the other part of flagrancy, correct? Correct,
Your Honor. And so then going beyond factor 3 to a case where there's intervening conduct, in particular flight, what I would suggest is that flight is even more interconnected to the illegal stop. It's more directly related to the illegal stop when it involves racial profiling, based on this court's precedent in Warren and Evelyn.
Don't we have, on attenuation, an issue where there are a bunch of cases, and I haven't done a deep dive on it, but I know there are a lot of cases where the person just flees, right? Either they run away or they run, and there's a line of cases that aren't good for you on that.
Well, Your Honor, the flight on foot cases are very good for me.
I meant in vehicle, where they, you know, in the New Jersey case, in the footnote speaks of that.
So, Your Honor, the flight in vehicle cases. So, first of all, I would suggest that the question isn't about whether the intervening conduct was appropriate. It's about the connection between the intervening conduct and the police illegality. Here, Mr. Diaz was fleeing direct.
Can I step on this? I just want to make sure I understand it. So if the intervening conduct here, let's the specific intervening conduct, he drives off like a maniac, they can prosecute him for that separate, they could have brought a criminal charge on that, right?
Correct. He can be arrested and charged.
Okay, so
The
that,
question is whether the illegality, whether there's attenuation from that preliminary illegality. And so that's where,
no, I just want to make sure I understand, because the thing that cuts against you is his flight is dangerous and has some criminal elements, so he's not prosecuted for it, I understand that. But I just want to make sure, when I understand conceptually how this works, when his intervening conduct, if it constitutes something criminal, he's not protected from criminal prosecution for that, right?
correct, Your Honor,
Okay.
correct.
I just want to make sure I
So he
get
could be arrested and charged with that intervening conduct, but the question here is one of attenuation. And so when you look at this court's precedent, Borges, Martin, and King, I would suggest the question is the relationship in duration and in nature between the conduct, the intervening conduct and that police illegality. Here,
So
Mr.
can
Diaz was...
may I stop you there, please? I think attenuation is evaluated from a point A to a point B. And point A is the initial police conduct. And point B is what? Because I think point B is actually the conduct that results in the evidence you're seeking to suppress.
Point B, right, I think under
Right?
Wong
So
Sung,
in
it's
this
the
case,
discovery
that's
of
right.
cocaine.
It's the discovery.
Right, and-
So in this case, because I think this is not something that was really, you didn't really tie to that in your brief. So here we've got the stop, and then we've got 2 point Bs, I believe. One is the inventory search of the car, which you don't challenge, and one is the discovery at some subsequent point, which I don't believe the record tells us when exactly, of the drugs in the woods. But it's not immediately after all this, because it's done by other officers. And I think after a search for your client, which was fruitless. So I think those are the point A and the point Bs. Am I missing something there?
No, I would agree with Your
Okay,
Honor. And
so then, isn't there a lot of stuff that happens between point A and point B? And why are those not taken into account in determining whether there has been attenuation?
So first of all, Your Honor, and I did raise this in my brief, is the Commonwealth did not present the details of how that cocaine was found.
We know some things about
We
it.
know some things about it, but we don't know exactly
We
when.
know it was after your client abandoned them.
Sure, it was after he went into the woods, which was 36 seconds after he started driving off. We don't know when exactly it was found, which officer found it, how they found it, where it was found.
All we
And
know
it's
is
the
that it was later.
And it's the Commonwealth's burden to prove attenuation. Not having those factors, Your Honor, as I argued in my brief, the Commonwealth didn't meet its burden.
Okay,
And
but
this
we
court could
do
stop right
know,
there.
but we do know, well, I don't agree with you that we can just stop there, because we do know it's after your client drove off, drove recklessly, crashed his car, abandoned the car, ran into the woods, and abandoned the drugs. Now, that's some number of facts. And I, at least in our in our attenuation cases, haven't seen anything where we said, with that constellation of facts, this is not attenuated.
So, first of all, our cases haven't addressed racial profiling. Our cases also haven't addressed an Article 14 violation where there was absolutely no justification for the stop and where the officer wasn't credible. But even putting those issues aside, when you turn to...
But how would those, I mean, analytically, how does that connect to whether or not the point A is attenuated from the point B?
Your Honor, because it's a three-factor test, and none of the factors are determinative, and factor 3, which is flagrancy, has been deemed the most important factor.
But wouldn't flagrancy also certainly comes to play in the Article 14 situation, right? So if you had, getting back to my earlier question, if you had a violation of equal protection where someone runs a license plate and the person's unawares, versus an Article 14 violation of a strip search, right? I think the flagrancy and the harm to the defendant is quite apparent, more so in the Article 14 violation, correct?
Correct. And I would also say it's not just flagrancy in that third factor, it's also purpose. And here, it's an unusual case, and it's beneficial for Mr. Diaz because the judge didn't say this was a valid hunch, but wasn't enough. There was no basis for this stop because the officer wasn't credible.
No, you've got the best factual findings you'll probably ever get in an equal protection case.
The best I've ever gotten, Your Honor.
Right.
Your Honor, I think, but picking up on what Justice Wolahojian was saying and going to what I think is helpful to look at the appeals court decisions, I would suggest there's a continuum of vehicular flight cases. This court hasn't dealt with vehicular flight, but the appeals court has. And I would suggest Mr. Diaz's case is way over here in favor of suppression. Then there's O'Laughlin, which is a defendant speeding off from officers in a parking garage. They have to blockade the exit. He then speeds to the top of the garage and throws a jacket full of drugs over the parking garage and runs away. The drugs were suppressed in that case.
Where do you line up in the circuit courts, in the federal circuit courts,
So-
on vehicle flight cases?
Your Honor, and with respect to the federal cases, I think they are more all over the place, Your Honor. I think in this case, the limiting principles, when you look at the federal cases to keep in mind is this is 36 seconds of flight, and we know under Borges we need to look at the duration of the intervening act. 36 seconds is extremely brief. I haven't seen a federal case like that. Article 14, we apply that more strictly than federal courts would, Fourth Amendment. None of the federal cases are dealing with equal protection, where the flagrancy is extreme. None of the federal cases that I'm aware of.
So if the person had gotten away and they stopped him 3 hours later, that would weigh against your client?
Exactly, Your Honor, exactly. And I think when you look at the key cases, Borges and Martin, this court's intervening act precedent, it's about, is the conduct directly related to the illegality? Here it is. He's fleeing from the illegal stop.
But he's going way overboard, though. You know, he's driving off in a dangerous way. I can't remember. He crashes right quickly, and he runs away after that. It's not like he's like in Martin, where he's slapping away the officer's hand. You know, this is like, does that matter, the flagrancy of his reaction?
So, Your Honor, I don't think it's determinative. And I think going back to the appeals court cases, because I do think that's helpful, we talked about O'Laughlin, but there's also Alston, which was the defendant drives away for 2 miles over a span of 5 minutes, nearly sideswipes another car. They have to use a mechanism in the road to deflate his tires to get him to stop. And the judge says that's suppression. And I think this court could look at this case, Alston and O'Laughlin, and contrast that with Coleman. Coleman was miles and miles a police chase. The defendant multiple times is crossing 50 feet across the median, going into traffic on the opposite direction.
Why does that matter, how successful a fleer he was?
It matters because, Your Honor, it goes to the test in Borges, which is the relationship in time and in nature to the police illegality. And so when you look at Coleman, you might say it started off as something that was very connected. Had it lasted a couple minutes.
So we look at New Jersey cases, because I think us in New Jersey are alone in the equal protection jurisprudence. In that Scott case, the footnote 5 says that the attenuation doctrine, it echoes what Justice Kafka said about the public policy component of attenuation in vehicle flight, says that there's a need to deter private individuals from engaging in dangerous conduct, such as fighting and fleeing the police after a constitutional violation. That's the public policy concern that cuts against your position, right, recognized by the New Jersey court.
I would agree with that, Your Honor. And that's why I'm not asking for a per se rule that all vehicular flight is going to establish attenuation or, frankly, not establish attenuation. I think it needs to be a fact-by-fact analysis. And I think, speaking about deterrence and incentivizing proper conduct, we can't have a scenario where there's a per se rule about vehicular flight, where police can stop anybody they want based not only for no reason, but for their race, the color of their skin. And then if that person drives off, they can seize whatever evidence they want. We can't have that as
Do we
as
have
a
any,
per se rule.
do we have any cases where the three-factor test was used when the intervening event was a new crime?
Yes, that's Martin. And in fact, Martin goes beyond this case because Martin, when he pushed the officer's hand, who was attempting to pat frisk him, not only was that criminal conduct on the face, but he in fact was charged with assault and battery on a police officer. And this court nevertheless suppressed the evidence. I think it was a gun later discussed.
In the appeals court case that got reversed, I remember it well, but because it was very odd, just because of the question that Justice Walhogen raised, which is it was a new crime.
It was a new crime, and that's not enough. And I think when you look at Borges,
Well, it may be enough.
it may be enough, but it's not enough per se. And when you look at Borges, the facts are he's being arrested. He actually struggles with the officers and attempts to get away from them. But this court in Borges distinguished the case from King because although he was struggling with officers, again, that's not appropriate conduct. That's not the way anybody should respond to being arrested. But that's not the question. The question is not the appropriateness.
But because of the racial profiling, the government gets its operating to endanger case, but not its trafficking case.
Excuse me, I don't understand.
That was my,
Oh,
that's exactly
exactly.
my initial
Correct, Your
question.
Honor. And absolutely. On the street, police can continue pursuit, they can make an arrest, and they can charge. But that's not the question we're answering here. This is about...
This is the kilo of cocaine or whatever it was.
Right. And frankly, when you back up, it's about public policy of one person being charged with a large amount of cocaine versus how is this court going to realize its goal of eliminating racial profiling, which in Long it stated was a goal.
Can I ask you please briefly to distinguish between flagrancy and purpose, which I understand have distinct meanings, and I understand your arguments for flagrancy here, and I understand that you have an affirmative finding that there is no basis for this stop, but you don't have a finding with respect to purpose that's similar to cases such as Borges, where they were looking for heroin and then they got the heroin. And can you address purpose here?
Yes, Your Honor, and I have two responses. The first is that we know the initial purpose was racially motivated, and the Commonwealth didn't sufficiently disconnect that initial purpose from the continued pursuit. All they ever did was continue to pursue him, and that initial purpose had no basis and was unlawful. And so that's how I would ask the court to analyze that factor. Secondly, I would ask the court to consider the fundamental purposes behind racial profiling, which, as I mentioned, one of which is to improper bias and stereotyping about the way someone looks in order to get in their car and search them and try to find contraband. So it's not only that his purpose was improper, it was flagrant, and it directly coincides to how we understand racial profiling.
Would the purpose of the unlawful conduct be in its pretextual nature?
Could you say that again,
The
Your
purpose of the unlawful conduct, that's the, right? Do we know the purpose of?
Well, the purpose was racial animus. That was the only purpose here. The judge did not credit the officer's justification that he gave for the stop. There was no justification. So the only purpose here was race, which is about as terrible a purpose as you could
I think
have.
as Justice Stewart points out, or the question asked, the purpose is usually, I'm going to do something in an illegally pretextual manner to further another investigation, right? That I can't do it lawfully.
Right. And so, and
Here,
I
it's
think,
just, it's, who knows why this
well, we know it's
other
race.
than it's racial.
We
yeah,
know
right.
it's race. It's the extreme. It's the extreme case of purpose and flagrancy, because not only is there, it's not a hunch that just wasn't enough. The judge did not credit his purpose, and he did say that the purpose was
Didn't he write something
unlawful.
like didn't he say it was a mystery of some?
So after the initial Article 14 hearing, he wrote in his decision that it was a mystery because there was no articulated way. The judge then sua sponte asked for a briefing after long, and after the second hearing, he determined this was in fact racially motivated.
Well, I think what the judge held was that it was at least in part racially motivated, correct?
Correct, correct.
And there being no other part.
Yes.
no other part. And so
So the purpose, the purpose, as you describe it, relates to, did the police purpose change at any point during the chasing of him, which you're saying that the car accident didn't change the purpose? And then secondly, the purpose doesn't only specifically relate to the evidence that was discovered.
correct. That's how I think a good way of putting it.
Is it that the officer stopped the defendant because he thought he was black, and so his purpose was just to stop him and search him for whatever he might find, whether it was firearms or drugs or just sort of a hope and a prayer
Right.
that maybe this guy, because I think he's black, is doing something wrong and I'm going to pull him over. And that's both the purpose and the flagrancy.
Right, and that's right, exactly. And that's really the only way based
So does
on.
the Commonwealth get to, I mean, so I guess I'm struggling with separating the reckless driving and endangering the public and the separation between that and the finding of the drugs incident to that arrest or investigation versus the illegal stop. Like, how do you say, so if the Commonwealth can charge your client for reckless endangerment, isn't part and parcel of that new crime the discovery of the drugs?
So I think what the attenuation, the overall picture is, did the taint dissipate?
It's a suppression remedy.
Right, it's a suppression remedy. And it's the question is, did the taint dissipate by the time they found the drugs? And it's the 3-factor test. And so when you look at the time, is incredibly brief, 36 seconds.
Well, that was not the time between then and the discovery of the drugs.
That's right.
It's
that's right.
longer than 36 seconds. We don't know how much longer, but it's longer than 36 seconds.
Correct. However, the Commonwealth
It could
did
be
not-
3 hours.
The Commonwealth did not present that evidence, and it is their burden.
How do you distinguish this kind of intervening? I'm trying to think of a holding here. How would you distinguish this kind of intervening illegal conduct and if the defendant had just shot the police officer? How do we distinguish that? It's a crime, serious crime versus serious crime.
So, Your Honor, I think what you can do is you can look at 2 sets of cases. The first being cases which are avoidance cases, where the defendant is directly avoiding the illegal conduct that the police are doing wrong. And that's the case here. He's directly fleeing from the illegal conduct. That was also the case in Borges and Martin. And then you can have another, when you look at the cases, there's another set that you can group together, which are the unprovoked attacks on police officers, which would be King, and appeals court cases like Mock. And so that's the holding.
What do you mean by unprovoked? They would have been, I mean, I'm not sure this is provoked.
Well,
It's right, it follows the police conduct. But does that mean it's provoked?
What I would suggest, Your Honor, is just like in Borges, struggling with police officers who are trying to arrest the defendant and running away and trying to get away is just like illegally stopping someone for racially motivated purposes and the defendant trying to get away, which is why these are avoidance cases. Again, I'm not saying it's going to be a per se rule where every time you flee in a car, but where it's incredibly brief, 36 seconds, this case should...
And abandoning the car is part of that flight? Why isn't that something new?
So, sure, it's part of the events, but I think what the Commonwealth relied on was the vehicular flight, because
But don't we look at attenuation de novo? I mean, that's the legal question. So we would have to take into account the abandonment of the car and the abandonment of the drugs.
Sure, Your Honor, but I think the cases are pretty clear that once police initiate a stop, abandoning contraband doesn't become part of the calculus. So, in other words, if police illegally initiate a stop, a defendant runs and throws a gun, that doesn't become part of the calculus.
Any further questions? Thank you, Counsel.
Thank you, and I would just say in conclusion, I'd ask the court to look back at its intervening act precedent and then forward at how racially motivated stops are going to be deterred and prevented. Thank you.
Attorney Lynch.
Good morning. May it please the court, Travis Lynch for the Commonwealth, asking the court to affirm the denial of the defendant's motion to suppress and the denial of the motion to reconsider. I think it sounds like everyone agrees that attenuation applies in the equal protection context, which makes sense because the court said in Laura that it does. So to answer the point A, point B question, as was suggested, there was a lot that went between the initial illegal stop and the discovery of the cocaine in the woods. The police were inferably looking for the defendant in order to arrest him after he left the traffic stop illegally and then recklessly operated his car, both of which are arrestable offenses. So they are looking for the defendant at that point. And then it sounded as if during opposing counsel's argument that it's conceded.
But they can prosecute him for driving to endanger or resisting arrest, I guess. But the question is there real attenuation? Does that all that activity attenuate sufficiently, right? That's the trickier question, right? You don't prosecute him for driving to endanger.
You're correct.
You don't prosecute him for resisting arrest.
You're right. There's no charge here for a 90-24 or a 90-25. You're correct.
Which there should have been, but there wasn't. So now we get into whether there really is attenuation. And that gets harder, right? Because it's quick. His fight is a direct result of the stop, which is problematic. Gets hard, right?
The fact that it's a direct result is not, at least on the circumstances of this case where the defendant unprovoked, like the officer.
Provoked. He's provoked, but instead of saying to the officer, hey, you have no reason to stop me, what are you doing here? He drives off and almost, he drives off and crashes the car and then he runs away, He doesn't sort of behave responsibly.
Right, the car's damaged, and then you can actually see in the video there are skid marks on the road that the defendant inferably left behind when he crashed the car.
So what is the length of time between the unlawful race-based stop and the discovery of the evidence?
It's not clear from the record when.
And to whom does that inure? To whose benefit does that inure?
I would agree that the defendant gets the benefit of that. And
All
that's-
right, so there's
I would
a
agree
short,
that
so we
there's-
don't know when, so the
Right.
government has not shown that. So on the second factor then, the circumstances that intervened between the illegal act and the discovery of the evidence, what was the evidence? I know what happened, right, because we see it on the video, and the officer testified to the defendant leaving for 36 seconds and driving dangerously. But is there a connection between being stopped while black and flight there? Or is there an absence of that connection? Isn't that the reason he's leaving inferably is because he's been stopped when all the other white motorists are allowed to go by?
I'm not sure what you mean by other. We don't even know.
Well, sort of to counsel's point on the analogy between this case and the Borges case, is there a direct connection between these intervening acts and the race-based stop?
There's nothing intervening, correct?
Well, the defendant just leaves the traffic stop. But in the cases where the person shoots at the police, there's nothing there either. But we still won't suppress in the shooting cases. Now, I think this is a more difficult case if we're not driving like a maniac on the public way. I think we would be, as the judge says, if the defendant just takes his traffic stop like he's supposed to, this cocaine's getting suppressed. If the judge even says in his findings, I would suppress if the defendant fled the initial traffic stop on foot. He would suppress that too, probably. The thing that makes a difference here is that the defendant is driving so dangerously and recklessly to the.
Does it go to that public policy argument that I alluded to in the New Jersey case?
Right. We don't want to, the exclusionary rule is all about deterrence, but at the same time, we don't want to encourage people to do what the defendant in this case did, which is driving dangerously and recklessly at everyone else's peril.
We could also discourage it by prosecuting it, because even he concedes they could have prosecuted him for driving to endanger, but they don't. So then the question is the additional deterrence that's provided by not suppressing the evidence. That gets a little harder, right? Because you have obvious deterrence, prosecute him for that. If he shoots the cop, you also prosecute him for that.
Right, but say in the shooting case, let's say the defendant illegally possesses the firearm that he uses to shoot the police officer. That gun is not going to be suppressed, even though it was only found as a result of the initial illegal stop. And obviously the shooting is not going to be suppressed either. This officer's observations and that video of the crash are not going to be suppressed. But they find the cocaine because.
If I change the hypothetical and you're shooting, if they stop him and the guy shoots him, they can prosecute him, but they may not be able to prosecute him for the drugs they find there, because that's separate. And that's a direct result of the stop that was illegal, right?
Well,
it's harder because it's I understand why you don't suppress the gun, but if I add another fact to that hypothetical, I can see you still suppress the drugs if it was an illegal stop or a race-based stop.
If the drugs are on him, you're going to get him for incident to arrest, right?
Well, if we found him, I don't think he's even arrested on this.
In Justice Kafker's hypothetical.
Right. Well, yeah, in that situation, we wouldn't suppress the drugs either.
Right.
So it really doesn't make any, they find the drugs in the woods because they're looking for him, to find him because of the observed traffic violation. That's what attenuates.
Well, actually, one thing that your brief doesn't address is that in the video, you actually hear the officer lie to his fellow officers, right? Because he says he tried to back up into me. And do you concede the video does not show him trying to back up into the officer, correct?
I would agree that the defendant doesn't actually move the car backwards. I think the brake lights are on. I'm not exactly sure what he meant by that.
But he's talking to the other officers by radio as he's looking into the woods, and he says, he tried to back up into me. So at that point, the misconduct by this officer is continuing, right? Like after he's already fled. I don't know if there's a single case we have with a bad stop where you see conduct that actually continues into past the moment of the flight.
I would agree that that's not particularly helpful, but I don't think that.
Can I ask you analytically, when we look at the three factors in attenuation and we argue or it's raised about a fleeing suspect harming a police officer, shooting a police officer, putting hands on a police officer, or causing a traffic accident and running someone over, that those really add a fourth component, that being the public threat to the public?
I guess that.
Where does that stuff that I just talked about fit into those three factors?
That's the factor about the nature of the intervening conduct. But, I mean, sometimes it seems as though that's the most important factor. But
Well, if the.
What is the nature of the intervening conduct? The circumstances,
It's in factor two, right?
I think it's factor
it's
two.
in fact.
That was my
The
understanding.
intervening circumstances.
Yeah, the presence of intervening circumstances.
Okay, so
I mean,
that,
a lot, I think,
that encompasses public harm, a threat to public harm.
yes, I think that the second factor does an enormous amount of work. There's a lot subsumed into that.
Okay,
I mean,
I
that's like the shooting the police officer situation.
All right, thank you.
Right.
So down below, you, in terms of attenuation, you argued, the Commonwealth argued only that the attenuation was caused by the act of flight, correct? The act of driving off and then driving recklessly. It didn't look at anything subsequent to that, or it didn't argue about anything subsequent to that. Am I correct on that?
I don't recall exactly what our memo below said, but that sounds correct. But we can affirm on any basis that's in the record. I mean, I understand that the Commonwealth obviously has the burden of proof here, and our primary argument was that the initial stop was legal because the defendant was speeding, but
Do you agree with my view that attenuation is measured from the point of initial, like the point A is the police conduct that's unlawful, and the point B is the discovery of the items that are to be suppressed?
I think that's a helpful way to conceptualize it.
And what happens, as Justice Stewart points out, where that illegal racist conduct is continuing? When is A measured?
If that would, I guess that would go to hypothetically, if the misconduct is continuing, I guess that's factor 3, the flagrancy of the misconduct, I suppose.
But if he's allowed to run, that would still be, if he flees without running the car, the judge says that's all part of, that's still illegal for them to chase him or something to that effect, right? I'm just trying to understand when does point A end? When does the illegality end here? I think you say it ends as soon as he starts rushing away, when this brake light goes on and he shoots off.
Right, because he's not even stopped at that point. The stop's over when he flees. So that's when A ends. There's nothing else illegal happens here. The inventory, assuming there's attenuation, the inventory of the car is also legal, not even challenged on appeal. There's other stuff they don't find cocaine in the car, but they find other things in there that were not suppressed. Unless there's any additional questions, I'd ask simply that you affirm.